Greetings, 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 greetings. It's Isaiah King, Clifford Jefferson, descendant of Godfrey, the fifth Calaban Jew, son of Folk, ruler of Jerusalem, reincarnation of King Edgar the Peaceful, which you know as Jesus Christ. Beside me, as always, my passionate and loving Archbishop Belmont from the House of Belmont, giving this marvelous lesson in regards to getting us or our people out of hell by way of us getting us back to the consciousness of the King, and there is an obligation of our judiciary to honor the conscience of the King on behalf of the King's subject, as implemented and dictated in the statute. We know that all statutes are derived from their legislative constitutions, which are the charters for the governing bodies who are there to protect your rights as trustees. This stems to the origin dating back to the original charters granted by the Constitution in regards to the original granting and the binding parties, i.e. the King, heirs, successors, i.e. versus the colonies who set the plantations and who broke the contract by enslaving the heirs and successors, who are the English successors, such as the English Third Temple Church and its members. I'll let Archbishop say a couple of words and we continue on with part 3, Way Out of This Hell.
Greetings once again, brothers and sisters. As I, Archbishop Belmont from the Noble House of Belmont. Well, like the King has said, this is the way how we get our people out of true hell. And it's not going to be by you getting on your knees and praying to imaginary people. You know, our ancestors lived. We walked amongst them, and we did call them lords and gods, but we knew their name as well. And their blood is the blood that courses through our veins. And the work that they're doing, we're doing this day as heirs. And you should be doing the same thing, but you went astray. And the only way for us to bring you back is by bringing you the truth of knowing who you are and where you are. And right now, you're in hell. Your fallen angels in hell. So with that being said, let's go ahead and finish this last part of this build. So that way, brothers and sisters who are ready to really truly take in the bread and water that the messengers of the day have came to bring to them can take.
Well said, Archbishop. Well said. Yes, sir. We come to the closing of part 3 of this marvelous lesson in regards to the hell that we're in. And the only way we can get out of this hell is go to those who are the keepers of hell. And these are the Lord Chancellors, who are judges who sits in the chambers of chancery. And it's through these avenues that our rights is going to be protected. And these rights are protected under the charters granted by our ancestors, protected within the statute that are saved from repeal. And we've been showing you, and we're going to continue to show you, because that's our obligation as your king, as well as Archbishop as your bishop. Like I said, this lesson is pretty much informative, and I'm pretty sure that it's without a doubt confirmed by Taj Tariq, who's not even the English heir. He's one if he chooses to be, but he had made his choice. But yet the information he's giving you is respectively belongs to us as English heirs. And we're going to prove this real quickly in regards to the origin of New Jersey, and when it was a colony before it became a state. All the other colonies who followed, which are now become states, was undertaken by the state of New Jersey and Virginia, because under the Virginia plan, the New Jersey plan called the Connecticut Compromise of 1790, 1787, between 1787 and 1790. Don't quote me. All right. So back to the original charter of the state of New Jersey. First of all, it's also called Lee's Resolution. Let's go here. Lee's Resolution. The article and part of series of the American Revolution, Great Britain. Now you see all the alternative flags that they've created. It says here, The Lee Resolution, also known as the Resolution for Independence, was a formal assertion passed by the Second Continental Congress on July 2nd, 1776, which resolved the 13 colonies. It didn't say states. It said the 13 colonies in America were free and independent states separate from the British Empire. It didn't say the English Empire, i.e. Albion. It said the British Empire. It said, in creating what became the United States of America. News of this act was published at the evening of the Pennsylvania Evening Post, and the next day, the Pennsylvania Gazette. And the Declaration of Independence is a formal document which officially announced and explained the resolution approved 2 days later on July 4th, 1776. So just because you declare something, don't make it legit.
Exactly.
Don't give it any validity, because you have a contract. You have a contract. You broke your contract by declaring yourself 13 colonies when you originally was just United Colonies, as we showed you in our last video, part 3. Was that part 3 or part 4?
I think it was that was part 2. We were on part 3 now.
Part 2. Okay, we on part 3. All right, so back to the Constitution. Have a line. I'm just going to briefly go back over what Archbishop went over. This is a constitution created by the state of New Jersey, what was a colony then. And as a result of what Great Britain under King George was doing, they decided to declare their independence. As you can see in Article 10 of the Constitution, it says that the captains, because this is under the militia, all right, maritime law, they was dealing with ships and stuff like that, transporting cargo, which is merchandise, which actually belonged to the kings of Great Britain. No, not the British. The kings of Great Britain was the Kingdom of England, Ireland, and Scotland. And this is after the Treaty of Union of 1707. So that all this has been under the Kingdom of Scotland, because England is no more in the picture. This is a problem. This is when you stole your estate, and we're about to show you how they did it. It says that the captains and all the inferior officers of militia should be chosen by the company. So all the cities, municipalities, boroughs, townships, villages are all ran by the county council. Under 48-1-6 of New Jersey revised statute, I don't know about the statutes in your other counties of all the other states, but you need to check them. It says that they're just there for what we call references. They're not legislatively constructed. So if they're not legislatively constructed, they're arbitrary, capricious, and outside of the law. All right, and we know that because they're companies. We're people, we're not companies. All right. So if the upper house, i.e. the council and the General Assembly, which is your what you call your provincial Congress at this particular time, are allowing the companies to create the interior, which is the inferior government, which is composed of companies under a militia government, which created by captains. All right. This is called your lower commissioner, or your what you call your freeholders. All right. Your governors, your mayors, these are your officers. All right. But as diligent students of our ancestors, and me come to not that I am king and Archbishop is Archbishop of the English Temple Church, reformed from the Reformation that was created under the House of Tudors through the War of the Tudors, under what we call the Wars of the Yorks and the Lancasters, as a result of the breakdown of the Plantagenet crown under the kings and queens of England, who created the Magna Carta that prohibited any type of tax outside of that was created by Parliament, going back to the House of the Plantagenet, which you see behind me in King's Bench, which is in charge of the House of Chancery, which governed the actions of the courts of common pleas, the courts of exchequer, which was dissolved by the Judicature Act of 1873, which created what they call the Exchequer Chamber, which were all those who are now subject to the state are in a place of hell. We're here to fix that. And the reason why you're in hell is by way of the amending of this actual contract, July 2nd, 1776, by the amending of the Constitution to the September 20th Amendment, which clearly stated, changed the word from colonies or colony to states, which we're going to see in this particular verbiage and July 2nd, 1776 Constitution. Anything you want to add to that, Archbishop?
And point of interest, and like the king said, you're going to notice this trickery that many of the brothers and sisters today have no understanding of, because it has been brought out of their sight. And we're here to bring it back into your sight, because just because you don't know that it exists does not mean that you're immune to the consequences that's going to come your way because of it.
Mm-hmm. Well said. Article 22 of the New Jersey Constitution under the Provincial Congress, because this is when after they declared their independence, they had to create a governing body of law for themselves, and this is their charter. But it wasn't the United States; they were colonies, y'all.
Mm-hmm.
It says that the common law of England. It didn't say the common law of Britain. It didn't say the common law of British. It didn't say the common law of America. It didn't say the common laws of the colonies. It didn't say the colonies of Netherlands. It didn't say the colonies of the Dutch or any other nation, Scottish or Irish. It said the common law of England, as well as so much of the statute law of England, i.e. statutory legislation, as have been heretofore practiced in this colony, shall still remain in force until they shall be altered by the future law of the legislator. Such parts are only accepted that as are repugnant to the rights and privileges contained in this charter. So the only thing they can't accept is the things that are repugnant to this charter, because they have to create laws for themselves. So the law for English people is not the law for them. That's why the only thing they will accept is that things that are not repugnant to their charter. And now not the charter as the colonies, because why? They're about to change it. How we know that? Let's look at it. Read the last section of this charter, Archbishop. This is all this is the agreement, the encumbrance that Great Britain had on the colonies. Read the encumbrance.
It says, provided always, and it is the true intent and meaning of this Congress, that if a reconciliation between Great Britain and these colonies shall take place, and the latter be taken again under the protection and government of the Crown of Britain, this charter shall be null and void, otherwise to remain firm and inviolable.
Now listen to what it says. It says, provided always. There's a disclosure there to the people, as well as to the trustees, and the true intent of why Congress was set up, of the Council and Assembly, right? That if a reconciliation between Great Britain and these colonies, it's not about states, it's that the colonies should take place, and that the latter be taken again under the protection of the government of the Crown. Who is the Crown? The King of Great Britain. You ain't talking about the jurisdiction, talking about the Crown. This charter, i.e. this Constitution, i.e. these statutes that govern this Constitution under this charter, which was there to keep their butt in line and to protect their heirs and successors by the laws that were still in place under the Kingdom of England. It says that if the latter, i.e. these colonies, be taken under the protection of the government of the Crown, i.e. the King of Great Britain, this charter, i.e. this Constitution and the statutes or that come along with them should be null and void, otherwise remain firm and inviolable back under the protection of Great Britain under the Crown. And the only way they can be a crown is they're a king. All right? But this was taken away as a result of this. Read part 2, Archbishop.
It says, the legislature of New Jersey amended this Constitution September 20th, 1777, by substituting the words state and states for colony and colonies.
Okay, so there's your trickery. They changed and broke the contract, and we know that according to Dartmouth versus College, as well as Plecker versus Peck, as well as Holmes versus Walton, Treble versus Riddle, they are in violation and treason of the original contract that protected by the sanctity of the parties, who are the English heirs, descendants of the king, i.e. the King of England, not King James Scottish descent, because he was the soon to be the first king of England, but that was de facto because it was under a commonwealth, and the commonwealth was resulted of the bishop wars that resulted from the bishop wars, which was the first series of wars as a result of ship money that was originally go back to us. So if anybody's supposed to be taxed, it's dumb. Why? Because they're supposed to be paying what they call free and common succors to the king. But they broke the contract because they changed the word states from colonies.
Mm-hmm.
Y'all see that? They changed the word states from colonies. That's a violation of the law because it clearly said it under the encumbrances. It said provided by, provided always, in this true intent, in the meaning of this contract, that if the reconciliation between Great Britain and these colonies should take place, and that the later take under the protection and the government of the Crown of Great Britain, this charter should be null and void, and otherwise remain firm and inviolable. Let's show where they broke it at. And we'll be coming to our closing. Read that, Archbishop.
Title 16, colon 1-28, saving of rights under charters granted by Great Britain. Says being section 12 on the act entitled an act to incorporate the trustees of religious societies, approved April 9th, 1878, saved from repeal. This section vested property held under charters of incorporation granted by Great Britain, and corporation created in place thereof.
Okay, so that means that when Great Britain dissolved by way of transfer to the United States, they were placed in corporations, as we see in Section 10 of New Jersey's charter. Corporations and companies took the place of the original parliament that existed at the particular time as a result of taxes being imposed upon the colonies that were not going back to the king. Why? Because we know under the Judicial Act of 1873, the Court in Common Pleas and the Court of Exchequer of Pleas started taking finances from the courts of chancery, which was composed of the House of Lords. Because we know that New Jersey legislation was composed of and created by the common people who selected the Senate, what you call the Council and General Assembly. So as we can see here, there is a reconciliation of Great Britain by way of us as officers of the Third English Church of England, reformed from the English Church of England as a result of what happened to the Tudors. So we as Corporation Sole, which is the natural person and corporation at the same time, and by way of what we call constituent corporation, we have merged. And the rights that belong to the original Corporation Sole, which was what we call Parliament under the King's Bench, which was created in 1215 under the Pensioning Crown through the House of what we call the Anjou Implantation under Godfrey V Count of Anjou. And it fixed what resulted in the House of Lords through the takeover through the marriage of Godfrey and Matilda, this daughter of Henry I, son of William the Conqueror, who established all this throwing confusion from the door.
Mm-hmm.
So you have to know your history. Why is that? Because I come back from mine. How we know that? In closing, it's a modern day statute, y'all, 2013, concerning properties, certain tenures and holdings turned into free and common sukuk. Read that.
46.3-2, the tenures of honors, manors, lands, tenements, or hereditaments, or of estates of inheritance at the common law, held either of the King of England or by any other person or body politic or corporate at any time before July 4th, 1776, and declared by Section 3 of an act entitled an act concerning tenures passed February 18th, 1795, to be turned into holdings by free and common sokage from the time of their creation and forever thereafter, shall continue to be held in free and common sokage, discharged of all the tenures, charges, and incidents enumerated in said Section 3.
Okay, and let's go here in closing, 46.3-10. Show you that ain't no more feudal tenure. This is a lolio, buddy. A lolio land. And the land can only be a lolio if it's held by a king.
Absolutely.
The America don't own land. They have a national debt.
Mm-hmm.
Where's the map?
I mean, it's at 46.
46.3-10.
46.3-, yeah.
This is the type of teaching you get here at the King's Bench. Believe me, what belongs to God is God, and what belongs to Rome is the Roman.
Yep.
Y'all better look at this. This is the law.
Things about to get shaky for those who've been living and sitting comfortable. Remember, you've been sitting comfortable in hell. I don't know how that works, but it's about to change up.
Mm-hmm.
All right, 46:3-10, fines and common recoveries abolished.
Now remember, common recovery was the way they could. Do I got it up here? No, I don't. But we went through that. If we look up common recovery, it was created by way of legal fiction to change intel estates to fee and simple. And the highest ownership of land here in North America is fee and simple. If you own it fee and simple, then I bet all my life that you got title insurance. And title insurance is the abstract insurance, which means that the deed that you have is not clear. It's not a clear title. I know this. We know this. If it's not a clear title, then you don't own it because it's not a lodio. It's fee and simple. The only way you can own it if it's a lodio, and this is going into lodio. Read, Archbishop.
All right, so it says, from and after June 12th, 1799, no fine or common recovery that has been or shall be entered, made, had, or suffered in any court of record of this state shall operate or be construed to be conveyance or assurance of real estate, or in any way barred to issue entail, or the reversioner or remanderment of their lawful claims and entries, any usage or custom to the contrary in any wise notwithstanding.
Okay, so anyone claiming to have a fee and simple estate here in what we call North America is not going to be entertained by any court of law in regards to an intel estate. And it says that, and you can't bar the issue. You're going to prove it. It can't be barred. Let's go right back here to this last statute in lieu of proving this is the lodio, 46:3-6. This is what we do, y'all. Read that, Archbishop.
46:3-6. All gifts, grants, or conveyances made prior to and after July 4th, 1776 of any estate of inheritance by letters patent under the great seal of this state, or in any other manner by the state, by the legislator thereof, or by the commissioners or agents of forfeited estates, or
freeholders,
or by other lawful and competent authority under this state, shall be and remain allodial and not feudal, and shall forever be and continue in free and pure allodium only, forever discharged of all feudal tenures and the incidents thereof, and all other services whatsoever.
Read it again.
It says all gifts, grants, or conveyances made prior to and after July 4th, 1000.
That means before.
Before. It's going on back to time immemorial.
Before and after.
1776 of any estate of inheritance by letters patent, which is coat of arms, under the great seal of this state, or any other manner by this state, by the legislator thereof, or by the commissioners or agents of forfeited estates, or by other lawful and competent authority under this state, shall be and remain allodial and not feudal, and shall forever be and continue in free and pure allodium only, forever discharged of all feudal tenures and the incidents thereof, and all other services whatsoever.
All right. Now let's bring your claim. Y'all all, based on what y'all read, y'all better bring your claim, or you are going to be in trouble. Taj told you, when the king's bench, under laws of chancery, under the king's consciousness in lieu of natural law, come for their estate, the world's going to be in trouble. How we know that? Y'all read it for yourself. This is what we do at the King's Bench.
Especially for all of those brothers and sisters who constantly keep asking, what are we doing for our people? like we say, we come for our own first, you know, and of our own, they must accept who we are. And if they don't accept who we are, you have no salvation. Like I said, you deny us in front of your friends and family. We deny you in front of our mother and father. You know, it's nothing personal. It's business. And we come and do our mother and father's business.
Yes, sir. So when we say family, we ain't talking about mother or father, brother or sister, none of that. We talking about English heirs.
English heirs. Exactly.
144,000. All right. What you're looking at right here is a core warranto. Before we get into that, let's look up core Queen Imperatrix. Todd speaks about this. Real brief. Queen Imperatrix is a statute passed by Parliament of England in 1290 during the reign of Edward I, the same one who came up with Chancery, y'all. He's from the pledge to the crown. The flag you see behind us prevented tenants from alienating their lands to others by substitution. As you just read in 46-2, 46:3-6, when it spoke about it should remain unloyal. So all those letter patents granted by the monarchs and kings is null and void now, because there's been a reconciliation between Great Britain by the King's Bench under the King and Archbishop, which is automatically a matter for Chancellor. All right. Instead, requiring all tenants who wish to alienate their land to do so by substitution. This status, along with the companion status quo warranto, also passed in 1290 with the intention to remedy the land ownership disputes and consequently financial difficulties that have resulted by the decline of traditional feudal systems in England during the Middle Ages. All right. Let's go back here. Docket number, Middlesex County, 012367-21, 11 November 17, 2021. Transaction ID number. This is the use to transfer from one jurisdiction to another, because it was filed in Middlesex County, whether faulty or illegal writ was written called the Bill of Middlesex. And as a result of us aware of this, of them acting under what they call the Courts of Exchequer Chamber under common plea without the authority of the king, that this matter is a matter for chancery, which we asked this court to do. All right. So as you can see the order, read it for him, Archbishop.
It's an order of J. Randall Corman, Superior Court of New Jersey, Civil Division, Middlesex Vicinage, 56 Patterson Street, New Brunswick, New Jersey. The Third Temple English Church plaintiff versus LP Homes, LLC, and Crocker Mansion Estate, LLC defendants. The Superior Court of New Jersey, Civil Division, docket number MIDDC-12367-21, civil action, order for transfer. The court pursuant to the complaint bearing the transaction ID SCP 202121525518, filed in E-Courts November 5th, 2021, and for good cause, it is on this 17th day of November 2021, ordered that this matter is transferred to the Civil Division, Special Civil Part, Bergen County, and it is further ordered that a copy of this order shall be served upon all parties who have not been electronically served through an approved electronic court system pursuant to Rule 1:32-2A, nor personally served in court. Honorable J. Randall Corman.
Okay, so this is a special civil part judge that deals with matters because we know that chancery is broken down into divisions now. So the Superior Court deals with civil, criminal, tenant, special civil part, that's tenant. But this matter that was transferred from Middlesex County to Bergen County to the special civil parts was not the proper jurisdiction for a complaint such as this magnitude in lieu of our Queen Imperatrix and lieu of a core warranto, established how the so-called occupants of this land, i.e. LP mansions, and if you want to see what it is, go on Wikipedia, look it up, and you'll see what we're talking about. And as a result of it being transferred from Middlesex to Bergen County from one judge, we didn't tell the judge to transfer it. He did it on his own sua sponte, based off his own judiciary review of the case at hand. Now look what this other judge decided on his review on lieu of the transferring of this case by the SCP number from Middlesex County to Bergen County. And we know Bergen County if you know any county of any county within any state of the United States before they became colonies, was the first court system set up and the first attorney for the first court set up in Bergen County, which was ruled by Bergen colonies under New Netherland, i.e. the Dutch, was Thomas Van Vleck. All right? They set up a fraudulent court system, which is not the court system set up under the courts of chancery or the courts of common pleas or the courts of ex-chamber or exchequer, which was set up by our ancestors. All right? Now, read what this judge said. We didn't ask this judge to do what he did, nor did we ask the Middlesex County judge who transferred to the Bergen County Court to tell this judge to do this. He did this on his own, upon his own judicial conscience under what we call the standard of review, or the golden rule, or the literal rule and interpretation of statutory legislation, or what we call the plain meaning rule. Now look at what this says. Read it from Archbishop.
It's the Honorable John D. O'Dwyer, or O'Dwyer, Bergen County Courthouse, 10 Main Street, room 358, Hackensack, New Jersey. The Third Temple English Church plaintiff versus LP Homes, LLC, Crockett Estate, docket number BER DC 1557221, civil action, order of transfer to Chancery Division. The complaint in the above instant matter having been transferred to Bergen County Superior Court on November 22nd, 2021, and a review of the file having occurred in the court sua sponte, having determined that the matter properly repossesses in the Chancery Division, or reposes, in the Chancery Division, and the court have determined that transfer to the Chancery Division is appropriate as to the relief sought. It is on this 14th day of December 2021 ordered that this matter is hereby transferred to the Superior Court of New Jersey, Chancery Division, Bergen County.
Okay. Now, where the King's Bench, under the authority of the English Third Temple Church, by way of its incorporation as corporation sole, I, as the king of the English Third Temple Church, and as a result of the descendants of King Godfrey the Fifth Count of Anjou, ruler of the Plantagenet crown, before they created the Angevin crown, ruled under the Plantagenet king under John, who sat the Magna Carta, where Jersey consists of, under Jersey, all right? We filed a complaint in lieu of our Lolio land being heirs of the Intel estate left in the trust by way of the charter that King James was a trustee of, because he was not the first king of England. If that was the case, that means England started in 1603. So that's a lot. So we see right here that as a result of us, the King's Bench, as well as me, the king, and Archbishop being aware of the information that derived from a king, known as the King's consciousness, then the only authority that's rightfully fitting for the situation is the Court of Chancery, because he's responsible for a keeper of the King's consciousness in lieu of conscientious law, i.e. natural law. So if you're saying that you're a natural people under natural law, then you better have a natural king.
Exactly.
All right? Because if the judge of the Superior Court can on his own consciousness transfer to this world, we can get equitable relief. Equitable relief. And equitable relief from the king can only come from a king, not a judge, not a president, because we know all these were creation by declaring something that became null and void by way of the reconciliation of Great Britain with the New Jersey Constitution of July 2nd, 1776, which was broken by the amending of colonies to states on September 20th, 1777, which we just proved went beyond a reasonable doubt. So I rest and I digress, and in lieu of my claim. If you say I am not who I am, then you bring your proof. Because if you don't, we're coming for our free and common soul, which is due to us. And I rest. Archbishop, you got the final words.
Well, there you have it. People from the Kingdom of England, Empire of Albion. We have shown you not only our works, but we're also showing you what statues going all the way back into a time that your mind don't remember are still agreeing with what we're saying today in your modern current state. You know, this is something for those heirs who have literally been suffering for a very long time. And they're going to continue to keep suffering until they decide to accept who they truly are as English heirs, going back to a time immemorial. 1189, and to go back further than that. Reason why we say 1189 time immemorial, because that's the furthest that the courts are going to recognize or care about. They already ruled against any case speaking any type of timeline that predates 1189. Like the king said, we're not there. We're here, and as far as we know it, and as far as long as we've been here, we have been underneath the status and the identity of English people without actually truly knowing it. And like you see right here, we still have the charters that are still protecting us today, even though they were granted by Great Britain. Great Britain is still upholding the rights and the powers of the English people. So just because we're not claiming ourselves to be British does not necessarily mean that we don't have the rights underneath the charters of Great Britain, because once again, we're telling you that we're English heirs that predates Great Britain.
Well said. And as we said, we're going to do other podcasts like we did, short spurts, to explain the difference between the Parliaments of England, Ireland, and Scotland, which goes by different churches. All right. And we're not the Church of England, Scotland. We're not the Church of Ireland. We're the Church of England, from the Kingdom of England, and that's where all those other kingdoms get their authority from. So with that, go ahead, Archbishop.
And that's the English church by chance, because we all know all of those other churches got infiltrated. Every church, the so-called Albion, got infiltrated by Rome, but the English church is the one that predates all of that. And like the king said, our church have been reformed, but we are the Third Temple English Church, the true English church for the English heirs, and not for the Roman Catholicism Protestants.
So with that, we're going to say peace and love. We know that you just had a holiday, which is what you call Christmas, but we're here to inform you that that day is noted for William the Conqueror, who stole your history.
Absolutely.
So look it up. That's William the Conqueror was crowned on December 25th. All right. So break that spirit, y'all. And from the King's bench to you, peace and love.
Peace and love.